Sometimes when I need to compose a challenging message, I rely on a council of women. It's always women because I have many years of Taboo board game experience, and a team of women will win every time. I think that's because women are encouraged to use all the words to communicate, and I, of course, encourage men to do the same, if for no other reason than to even out the Taboo teams. My first Council of Women messaging meeting followed a weird birthday party in which the young man I was dating ignored all of my friends and criticized me for consuming a single mojito with my dinner on my 21st birthday. I gathered my trusted sorority sisters and inquired how one might end things because I'd not had to do that before. It was immensely helpful to draw on one another's experiences and find a message that was both gentle but clear, a message that was firm and still polite. The relationship at the heart of this episode was similarly ill-fated. I have nothing to suggest that a council of women helped a young woman select her messaging. But we do know that there was a text message breakup that was clear, but apparently not firm. Unfortunately, the ensuing relationship relapse was neither gentle nor polite. But much more alarmingly, it also wasn't consensual. For that young woman, the council of women came in the form of support following sexual assault. This is Conduct Unbecoming. I'm Erin, and I'm your host. I'm leading off with what feels like a familiar heads up. This episode discusses sexual assault. I do get into the details of it. And if that means that this episode is not for you, that's all good. Catch me next time. Anton Soloshenko began his career in the Air Force as an IT systems technician. He enlisted in 2019 and, as best I can discern, spent some unknown amount of time in South Korea and in Germany. From what I gather, in 2020 he was named Airman of the Year, but I really don't have much more detail than that. I do know that while he served, Soloshenko worked towards an associate's and then a bachelor's degree. Shortly after he enlisted, the United States Space Force was created. With what I'm sure he felt would be exciting opportunities ahead, and perhaps inspired by Netflix's Space Force, Soloshenko transferred to the Space Force in June 2022. There, he continued to serve as an information systems security officer and settled in for a stint in Aurora, Colorado. While in Aurora, he worked on a variety of projects designed to safeguard the Guardians and their computer systems. But in his free time, Soloshenko leveraged technology to connect to the locals in Aurora. By which I obviously mean that 21-year-old Soloshenko was on dating apps and swiping up a storm within what seems like minutes of arriving in Aurora. The same month that he started at the Space Force base in Aurora, he matched with an 18-year-old we'll call Laura, and the two began a sexual relationship. It seems that his intimate partner, Laura, enjoyed the sensation of pain during sex and described sex involving pain as, quote, almost the only type of sex that they had during their relationship. She estimated approximately 75% of their consensual encounters involved Soloshenko, making it difficult for her to breathe. At least one time, their consensual actions left visible marks on Laura's body. And I'm not sharing those details to kink-shame Laura or Soloshenko, but rather to offer an important backdrop. To highlight that there were things that Laura requested and consented to that others might find objectionable. The reason it matters that Laura consented to and requested this behavior before is because she was obviously entitled to withdraw her consent at any time. On July 7th, 2022, Laura and Soloshenko sexted back and forth in advance of their date, describing their desires. She described wanting him to stop, but also not wanting him to stop. They engaged in what had become routine, rough sex later that evening. And even though they were only a few weeks into their situationship, Soloshenko confessed that the way they engaged with one another, the way in which they were intimate, made him feel like a, quote, withered husk. He described being exhausted and uninterested in continuing the sort of sex the two had become accustomed to. He said that style of intimacy made him exhausted and depressed. The following day, the 8th of July, Laura and Soloshenko continued their conversation about their relationship, and Soloshenko clarified. He was totally willing to still have sex with Laura, but he didn't believe she was someone he could take home to his mother. Rather unsurprisingly, being told that he saw no meaningful future with her prompted Laura to end things with him via text message on July 9th. She explained that they just weren't that compatible anymore and that she just wasn't that into him. A few days later, Laura engaged in a one-night rebound fling. Then she consulted with her therapist, who advised her to maybe give celibacy a try, to decenter men and to take care of herself. She'd ignored similar advice in the past, but resolved to make a real change, to do that internal work. And wrapped up in that resolve was her decision to be celibate. Just 10 days after their breakup, on the evening of July 19th, Soloshenko sent a test balloon text message. The message explained that he missed her and he didn't believe things should have happened the way they happened. Just days into her celibacy journey, Laura attempted to connect beyond the physical level and admitted that she missed him too. She apologized for what she said to him, declaring that it wasn't true and acknowledging that it wasn't kind of her to say. With the successful test balloon text message, Soloshenko invited Laura over and, when she asked, reassured her it wasn't just a booty call. Booty call is, for your knowledge, a term defined in footnote 8 of the opinion. Judicial definitions of Urban Dictionary terms hold a special space in my heart. With his reassurance that the visit wasn't about sex, Laura dropped by. They sat on his couch and talked for a bit before Soloshenko leaned in for a kiss. She reciprocated, but clarified to him that their interaction would only go as far as kissing, that it needed to stay PG because she was committing to celibacy. Soloshenko reassured her that that was fine. By all accounts, including Laura's, she was an active and willing participant in the kissing. The two talked more about how their flash-in-the-pan relationship ended and apologized for the things they said that hurt the other. Soloshenko had only been in the apartment for a matter of weeks, so he was still getting settled. In the 10 days that they'd been apart, he'd purchased some new furniture and used that fact to take Laura on a tour of his new purchases. And wouldn't you know it, that furniture included 2 new nightstands in his bedroom. Laura claimed that she was focused on their conversation and didn't worry that they were walking into his bedroom as the next stop on their new piece tour. When they again began kissing, Laura pulled away and reminded him that this was as far as they were going to go, and he confirmed for a second time that he was fine with that. But he wasn't. Even though Laura texted him that she didn't want to have sex, and twice told him that she didn't want to go past kissing during her visit, Soloshenko became more aggressive and pinned her beneath him. When he started to get handsy, Laura disengaged from kissing him. She described freezing in the face of his aggression and him pushing down on her face with his hand, making her feel like she could not breathe. With that pressure exerted, her ability to speak came and went. But she said no, an estimated 20 to 30 times. When she slid her hand between their lips as a physical barrier, he removed it and continued. When he went to remove his own shirt, she tugged it back into place, saying, "If you take your shirt off, this is going to go to the next place." But that kind of seemed his point. It didn't deter Soloshenko, who had no celibacy curiosity. She then tried to use his shirt as another physical barrier to kissing, but Soloshenko removed that, too. After saying no at least 20 times, after twice creating physical barriers to his lips, after repeatedly telling Soloshenko that she did not want to do anything more than kiss, after having her face pushed into the mattress and feeling like she was suffocating or being strangled, Laura was scared. Soloshenko told her he knew she wanted it, wanted him, and demanded she take her clothing off. Laura complied, saying she felt fearful that he would escalate and the situation would become more violent and more aggressive than it already was. She felt overpowered and like she couldn't really get away. She felt like she didn't really have any choice. When Soloshenko began performing penetrative sex upon her, he leaned down and bit her neck and either one or both of her breasts. She described extreme pain from the act, but Laura again froze in the face of the act that she had not consented to. The assault lasted an estimated 15 minutes, during which time Laura did not further resist or tell Soloshenko to stop, but she also didn't participate. After, Soloshenko laid his head on her chest, acting affectionately toward her. She said that she found that really confusing. Perhaps starting to finally sense that the vibe was off, Soloshenko asked Laura how she was feeling. She asked if he wanted to hear the truth or a lie. When he asked for the truth, Laura revealed she wasn't okay. He assured her that breaking her promise to be celibate was totally his fault, so she shouldn't feel badly. Any whooshing noise he heard was the point, sailing past him. He hadn't realized, or perhaps hadn't cared, that Laura wasn't engaging in their sex. He hadn't realized, or perhaps hadn't cared, that Laura wasn't enjoying herself. He hadn't realized, or perhaps hadn't cared, that Laura did not consent to what happened. And I think this is a good time to pause and talk about implied consent. Implied consent is consent that isn't expressly granted by a person, but rather consent that is implicitly granted by someone's actions and the surrounding circumstances. Laura taking her clothing off at Soloshenko's direction is certainly one action that might contribute to the belief that Laura impliedly consented. Perhaps those text messages from nearly 2 weeks before the incident might be read as relevant to whether Laura provided implied consent. There are some who seem to believe that not fighting back, that not resisting, is an act of implied consent, and with those people I vehemently disagree. But looking to Laura's words and affirmative acts, the fact that she said no in excess of 20 times the barriers she put up, Soloshenko could have leaned into only yes means yes culture and just asked if she was okay with continuing. After Soloshenko so clearly missed the issue, Laura rose and dressed. She left the bedroom and laid down on Soloshenko's couch, curling up into a ball. This provided a further clue for him that something was bothering her, which he again assumed had something to do with her express wish to remain celibate. Laura, who later stated she was still processing what happened, didn't confront him with what he'd done, but with respect to the celibacy commitment, explained that she'd engaged in meaningless sex with another man on July 11th. She stayed at Soloshenko's apartment for about an hour after the incident, then called a close friend on her walk to the car. She began crying, grasping the extent of what just happened and realizing just how bad the situation was. Laura called her sister and mother next, before driving to her mother's house and revealing a bit more of what happened. Her mother suggested going to the hospital. While Laura reached out to her tribe of women, to the women she trusted with the details of her life, both good and bad, rewarding and challenging, Soloshenko sent her 2 text messages. The first read, "Come back, I'm horny." When that didn't elicit a response, he claimed he was totally just kidding and wished her a good night. Laura didn't respond, explaining later that there is no response to such a request following sexual assault. In the cool light of morning, Soloshenko wrote again. He wished her a good morning and said he hoped Laura didn't hate him too much. She didn't respond, but after she finished a shift at work, she reported to the hospital for a forensic sexual assault exam. I have only met a handful of practitioners who perform safe exams, but I know that they are powerfully compassionate in the difficult work that they do, and that they are critical in the pursuit of justice in sexual violence cases. In general, victims of sexual assault in the military, inclusive of active duty service members and dependents, are not required to pay for the forensic medical exam that might bring their assailant to justice. However, in April of this year, a Defense Department memo ordered the Defense Health Agency to stop providing sexual assault resources to civilian workers and contractors. The edict indicated that if someone isn't eligible for care within the military health system, they cannot receive that care, inclusive of safe exams. That means that local civilians and contract workers, even if assaulted by a member of the United States Armed Forces on a military installation, are responsible for the cost of their forensic exam. If their insurance doesn't cover that exam, they are expected to pay out of pocket. Now, most states care about the victims of sexual violence and have programs that provide the exam free of charge. So this new policy will likely have the greatest negative impact overseas. More details about that change for those who are interested are included in the Military Times article linked in the show notes. As you may have guessed, I am not a fan of the change and believe it will only serve to impede the prosecution of sexual assaults. I think the natural, predictable, and perhaps intentional result of this change is that victims of sexual assault either won't seek or won't receive a forensic exam. Absent those exams, absent successful prosecutions, I think somebody could erroneously assert that sexual violence in the military decreased. But returning to Laura. After she reported her assault at the hospital, a nurse guided Laura through the exam, inquiring at each step whether she had Laura's consent. She asked if she could collect swabs, take pictures, measure injuries, clip or scrape her fingernails. The photos captured marks on Laura's neck and breast, consistent with her report that Soloshenko painfully bit both locations. She described her difficulty breathing during the assault. When the nurse asked about her sexual history with Soloshenko, Laura recounted that there was no history of him threatening her or inflicting injury upon her. Although they'd engaged in rough sex before, although she had requested erotic asphyxiation or breath play, that was all consensual. It wasn't done under threat, and it wasn't done to inflict injury. Laura also reported her assault to law enforcement that same day. The sordid details of their brief romance and the uncomfortable details of the assault came out through Laura's testimony. Soloshenko exercised his right to remain silent. And as we would expect, Laura faced a grueling cross-examination. Counsel drilled into what she meant when she said Soloshenko forced her legs apart before penetrating her. She explained that she'd been frozen, that she wasn't a willing participant, that she hadn't moved her legs herself. Counsel challenged her, saying she never reported that force to the nurse examiner, to detectives, or to trial counsel. They asked Laura why she never disclosed the history of consensual rough sex between herself and Soloshenko, why the first time it came up was at court-martial when the defense questioned Laura about the text message exchanges she had with Soloshenko. Defense accused Laura of deleting a supposedly exculpatory text message that Soloshenko sent, then labeled her testimony as inaccurate when she recalled blocking him for a short time before unblocking him at law enforcement direction. Defense also highlighted that Laura could remember some details of the night, but couldn't remember whether Soloshenko injured one breast or both. They wondered why Laura could recall that she said no so many times, but couldn't remember how Soloshenko reacted to the news that she'd slept with another man just 2 days after their breakup. Soloshenko's defense revolved around a claim of mistake of fact, arguing that he'd made an honest and reasonable mistake because he believed that Laura consented. In the moment, he'd told her that he knew she wanted it. She undressed when he directed or asked her to do so. She stopped physically resisting him and no longer verbally protested. He inflicted pain in ways she'd previously consented to, and when it was over, he attempted to, soothe her concerns over her celibacy and to sort of take the blame for her broken promise to herself. Could all that mess coalesce to form implied consent? Looking at the other side of the coin, Laura texted Soloshenko she didn't want to have sex with him, she didn't want a booty call, and twice stated her explicit limit of kissing that night. She said no to his aggressive and increasingly insistent actions between 20 and 30 times, trying to put her hand, his shirt, and space between their mouths and bodies. She didn't kiss him back, and she didn't participate. In spite of defense counsel's seemingly successful impeachment and dogged word selection, a mixed panel convicted Soloshenko of one specification of sexual assault and acquitted him of one specification of assault consummated by battery. They sentenced him to hard labor without confinement for 15 days, reduction from E4 to E3, and a dishonorable discharge. On appeal, Soloshenko challenged the sufficiency of his convictions, both legally and factually. He also challenged the military judge's decision to admit Laura's statements as an excited utterance, asserting instead that the statements were inadmissible hearsay. There's a footnote that I particularly appreciated from the Air Force Court of Criminal Appeals that I'd like to read in its entirety. I think it treats a difficult subject well, and I find it thoughtful and clear as to Laura's previous consent. Footnote 17 reads, "Engaging in consensual acts of rough sex, even sex like that Soloshenko and Laura had engaged in that involved pretend non-consensual acts, consensual bondage, consensual infliction of pain, and consensual breathing restriction, does not license subsequent non-consensual sexual activity. However, we acknowledge such consensual behavior might, in some circumstances, increase the possibility that participants in such acts later might misperceive another participant's consent." Stated differently, in some circumstances, feigned non-consent may make the line between consent or non-consent in subsequent situations harder to discern and render misunderstanding regarding consent more likely. The circumstances of this case, however, clearly point in a different direction. Aside from a totally personal pet peeve about stating something differently or putting it another way, I found that footnote commendable. I didn't want to turn the focus of this section without highlighting its important message. The family friend that Laura called on her walk to her car testified at the court-martial. Defense challenged that friend's recitation of what Laura told her as hearsay, an out-of-court statement offered for the truth of the matter. The military judge heard brief argument on whether Laura's statement, coming through the friend's testimony, was hearsay. The judge determined that it was hearsay, but found it was an excited utterance and could come in as an exception. To refresh everybody about the conversation around hearsay and exceptions, hearsay is excluded unless it's subject to an exception, and the law favors an exception that has some other indicia of reliability. A dying declaration where there's no reason left to lie, a statement made pursuant to seeking a medical diagnosis or treatment, a public record, or an excited utterance where someone doesn't have the time to formulate artifice and just word vomits. The friend testified that Laura called her very upset, that she had just left Soloshenko's apartment, that they'd had sex, and that Laura hadn't wanted to. She described Laura recounting pushing Soloshenko off of her. The military rule of evidence that governs excited utterances, MRE 8032, defines an excited utterance as a statement relating to a startling event or condition made while the speaker was under the stress or excitement that it caused. So to qualify as an excited utterance, first, the statement has to be spontaneous, excited, or impulsive, not the product of reflection or deliberation. Second, the event prompting the statement must be startling. And third, the speaker must be under the stress of excitement. The AFCCA assumed that the assault was startling, but they quarreled with the rest of the military judge's implicit findings. The court believed that Laura spoke to her friend after reflecting on the startling event, her assault, and deliberating. I think we can all see the string that got them there. The assault happened, Laura dressed, she curled herself into the fetal position on Soloshenko's couch, and had a subsequent conversation with him. Then, 60 minutes after the event happened, she left the home and called a friend. That certainly feels like there could be time for deliberation. But I also see how the military judge may have arrived at their decision, perhaps determining that the realization that she had been raped was its own startling event, prompting Laura to call her friend in tears and explain what happened. But I don't think that's been accepted as a cognizable startling event, or at least perhaps not under these circumstances. So, the AFCCA determined the military judge erred in allowing the testimony in and that the evidence shouldn't have come in under any of the other exceptions to hearsay. As we've explored before, it's not enough to have an error at trial. The error has to matter. The error has to have a prejudicial effect if the appellate court is going to reverse a conviction. In their prejudice analysis, the AFCCA highlighted where the government's case was weak, where they could perceive cracks where the mistake of fact defense might shine through. But they believed that the quantum and quality of evidence introduced through the friend's testimony about Laura's non-consent was marginal, and even in a comparatively weak government case, not particularly influential. Accordingly, they concluded Soloshenko suffered no prejudice from the erroneously admitted testimony and affirmed the judgment. Thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com or on conductunbecomingpod.com. Join me next time when we peel back the curtain on PTSD and survivors of sexual assault. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, authorized, or endorsed by the Department of Defense.